Mr. Pennington-Benson, I don't know if there's anything you wanted to say, having had the opportunity to take instructions on that particular point.
There is. Just to find the little scrap of paper that we've written it down on. So it may make sense from while I was just to say in full what we ask for. Not necessarily what we'll get, but what we'll ask for. First of all, we ask paragraph 1 to allow the appeal. Paragraph 2, we ask for finding or a declaration that a finding that the defence of fraud / counterclaim of fraud cannot succeed and should not proceed. We would ask for a declaration that the compromise documents are valid and enforceable, or simply a direction that the High Court makes an appropriate declaration following the finding by this court that the fraud...
I'm sorry, the fourth was? Sorry, a declaration
so I've said
the compromise agreements were valid.
Yes, so the board should declare that the compromise documents are valid and enforceable, or the board should direct the High Court to make an appropriate declaration based on the board's finding that the fraud allegation can't proceed.
Yes.
Then, in the alternative, if the board's not willing to do that, we would ask that the dispute over the compromise documents be remitted to the High Court, if reasonably practicable, to the same judge, to finish trying the case.
Yeah.
I'll come to that, yes. And then the next point, I'm not sure what number it is, but the next point, alternatively, the dispute over the compromise documents should be sent back to a different judge. But in either case, our submission is that that dispute should be tried on the basis of the pleadings and the witness statements as they stand, accepting as we do the risk that my Lord Stevens pointed out.
Thank you.
Thank you.
Silence.
No.
Can
I just before we leave, might I just ask a follow-up? So this says nothing about the trust issue.
No,
Is that right? Because
I was just dealing with the...
Yes, I think the point being made to you was that insofar as there was any issue as regards the trust question, that might produce a problem, but I see the way that you've dealt with it. Yes, thank you very much. Sorry.
Have I? I think so. All right.
Just to be dealt with on the pleadings as they stand.
Yes. But
with your fallback position, provided it has been properly pleaded.
But that would be a matter for argument before the first instance judge. But of course, our case before the board is...
Without any power to amend.
Correct. But of course, our position before the board, this is what I make sure I am answering my Lord Barrow's question correctly, is we say that we should hang on to the judge's finding about the Siparia land because the Court of Appeal was wrong on the pleading point.
Yes.
And therefore, if we win on that point, it doesn't matter whether it's been properly pleaded or not because we hang on to it anyway.
Yep.
Yes, thank you very much. Yeah,
Mr. Simon.
Obliged, my lords. My lord, when we took the break, I think the respondents were described as having abandoned the probate proceedings. Because I think my lord was making the point that High Court and the Court of Appeal, they were supposed to proceed with the probate.
I
And there was an apparent abandonment.
I think I was told by your opponents that the probate had not been obtained.
No, it was not.
And my question was simply, well, why not?
Yes, no. But the word abandonment, I think, is what I heard, and maybe I'm wrong.
I don't recall using abandonment, and I didn't.
Maybe I'm wrong. But what was happening then, let's remember that we had that 2 years of virtual hearings and probate registries and so on were closed, so that we only could communicate in writing and request files and so on, but no one could go into the registry. So for 2 years, nothing was done in the probate proceedings. And we made every effort to try to get the probate proceedings going.
Does that mean to say that no probates were granted during that 2-year period?
Well, I know certainly we didn't have anything done, but people were not physically going.
When did you write to the probate office asking them to grant probate to your client?
It was shortly after the order from the court, my lord.
And what does that mean? And what was the follow-up to that? What does that mean shortly after?
Shortly after the orders from the court, from the Court of Appeal, that the caveat should be lifted. And as my friend on the side indicated, the order was sent to the court,
Yeah, but sending the
to
order
the registry,
sending the order to the registry isn't an
the
application.
registrar, yes.
Isn't an application for probate.
Well, no, the application was already filed. The application for probate was already filed. The caveat was there preventing the grant, so the registrar would do nothing until the issue of the
You must have been
caveat.
sadly disappointed that there was no reply to this request for the grant of probate. What happened next?
Well, my lord, the registrar,
Well, I think you're getting some instructions.
yes. My lord, when the application for probate is made, the registrar deals with that. And our probates in our jurisdiction takes from 2 to 5 years.
What, just to get
For a grant.
common form probate
For a grant, yes.
in common form with no
Yes.
opposition? 2 to 5 years.
Yes, my lord. Very rare you would get a probate within a year. Very rare. And they have files, they tell you, well, it is before the registrar. And we inquire week after week, month after month. But it takes a long time.
You did inquire week after week and month after month in this case.
My lord, because the registry was closed, so all we could do is to write.
Yes.
And we knew that the registry
Well,
was
does
closed.
that mean to say that you wrote week after week, month after month?
Not that we wrote, during the period of the COVID, no. We would not do it week after week because you would write them. And the last information we had was that the files were in another place and had to be retrieved because of the period during the trial and the order. So the files were not actively before the registrar for the grant of probate. So there was nothing that the applicant could do to hasten the probate.
So if the board records all that in its judgment and makes it available to the probate office, there won't be any comeback in relation to that. They'll agree with that.
The probate of the registry,
Yes.
they will agree with that.
Yeah. Okay.
They will agree with that. So, that, my lords, was the issue regarding the delay in the grant of the probate.
But what's slightly troubling me, Mr. Zunas, is this. What's slightly troubling me is this. Your case, and you say the Court of Appeal's decision, is that it's premature for any court to decide the issue as to the validity of the compromise agreement until probate has been obtained. And if probate takes, let's say, another 5 years to be obtained, it sounds as if the logic of your position is that so will it be another 5 years before the question as to the validity of this compromise agreement can be finally, or even initially, decided at first instance.
Well,
I find that deeply troubling.
it is. I can understand why. Because as I know in other jurisdictions, and perhaps here, you can have applications for probate online, and you get it in a quick time. It's supposed to be, because a man leaves an estate for his children, probably leaves money there for them, and they don't get it. And in the meantime, they lose a lot. And in this case, Mullers will find it troubling as well, that here's a man who went the proper way, made a will, and thinking that he did the right thing. Application for the probate was made within the shortest time that we could there. He died in 2008. Shortly after, in 2009, the application was made for probate. And then we had the caveat stopping and these proceedings. Now, in terms of the concern, and quite relevant as well, if the probate documents, the compromise documents as you have them, is to put aside the will, the directions under the will.
Wondering why then the internet, if you put in time to obtain probate in Trinidad and Tobago, it says it takes 6 months to a year.
That's not the reality, Babu.
Okay.
That's not the reality. I have one that is pending now 3 years, and one over 2 years.
Well, we have to.
The difficulty that we saw in the granting or dealing with the issue of the compromise agreement, my lord, as I said, it is setting aside what the will says. The will simply, and it's a very simple will, that the executor would sell all the assets, and after you pay all debts and usual claims and so on, that you will distribute in a certain way to the children, his 4 children. That is very clear in the will. And I say it is one of the simplest of wills that we can have. When we apply for probate, we, as in every other jurisdiction, you will set out in the inventory the estate that you apply for probate for. But you cannot set out the debts that the testator may have had, or any claims against any property, mortgages or things like that. These will come from creditors after the estate is granted, or they may warn you in advance that these are claims that would come from the estate. Now, since in this case we have real estate, real property, and none was given to any specific devisee, not to any of the children, the compromise agreement is saying, give property, Black Acre, to me, and I want 50% in White Acre, and so forth, specific things that the appellant was asking for in the compromise documents. Now, we did not know, and perhaps we do not know now, whether there are any liens against any of these properties. Quite apart from the debts that the executor will have to pay, we do not know the size of that, the extent of it. We do not know on any of the properties that were left, if there are any judgments, if there are any liens against them, if there are any claims against them. And the only time you would know that is if you do a title search when that time comes to do a title search. So,
what search?
Pardon, my lord.
Search.
Title search is the search of the title to the property, to trace the ownership. We have a two-tiered system. We have what is called the Real Property Ordinance, where the document, the deed itself, will have everything recorded.
Yeah.
And then we have what we refer to as a common law system, where you have to search the registry to find out if there are any judgments or any liens, mortgages, and so on. As I say, the difficulty that the executor, assuming now that we move from making the appellant the legal personal representative, which I do not think that she could have succeeded at any rate. But when you apply for probate of a will, there is no guarantee that the probate will be granted, my lords. The registrar will make inquiries, and after the estate, the advertisement of the application, there may be someone with another will that he is claiming, so that there is no guarantee that this estate will be granted to this executor.
Presumably there has already been advertisements. Your client applied
Yes.
for probate,
Yes.
and that prompts advertisements.
Yes.
And has there been any response to those advertisements, making some other
Except for the caveat.
Yeah.
Except for the caveat. No.
Yeah.
But I think the major difficulty really is to determine what from the estate can be distributed. But this agreement is asking that specific property be given to the appellant and specific property be given to the children. The executor may not be able to comply with that if it is that there are any encumbrances on those properties, or if the indebtedness of the estate, which still has to be determined, will be such that certain properties will have to be sold. He will not know which one he will have to sell. So that
Am I right in recalling that the compromise agreement and deed made provision for Lauralee to put a substantial sum of cash into the estate for the purpose of funding it to pay debts and expenses in exchange for transfer of certain properties in Trinidad out to her? Is that right? Is that the right recollection?
Well, yes, in the agreement she has agreed to pay certain sums of money. She has paid certain sums of money to the Florida lawyer, and that is Farbstein. But we still do not know what the extent of the indebtedness of the estate is. And of course there is money in the estate, in some safety deposit box and so on. We don't know what money there is, if there is anything there. But there were businesses running. So the appellant was running the businesses. Whereas it should be for the executor to gather the estate. So that, assuming that the court there, either the High Court or the Court of Appeal, will say, yes, we will determine this document, the agreement, whether it is valid or not. And it will, according to the claim by the appellant, it be given immediate effect. What does that mean? That once that is done, she will go distributing properties? As what? As LPR? No. If she is not constituted in law as LPR, and she could not be, because the will says who the LPR is. Of course, they are asking that you remove him. Now, the alternative position is leave him there and direct him to do what the agreement says. But there are difficulties either way. Remember, an LPR is not only there to distribute the property. He has to pay the debts, he has to pay claims. If anybody has to make a claim against the estate, it's against the executor when he's constituted the LPR. So if the LPR were to be removed and you put the appellant, as you say, give me the powers, that person cannot sue her or bring any claim against her because she's not the lawfully appointed executor of the will. And the person who has to make the claim against the executor will be after the grant is made to him. Suppose the grant were not made to him. Now, my lords make a very important observation that if this goes on for 5 years, 6 years, 10 years, we have to face that in our jurisdiction.
Well, how would it be resolved in the case of an agreement which did exist as between the beneficiaries? How would it be resolved? I mean, what you're putting to us is that when one has an agreement of this kind, one can never give effect to it.
No, I don't.
How would one give effect to it in your submission?
Well, once the probate is granted, and the estate, the executor then will determine what he has to pay out, then you can come with an agreement, and if the agreement can be put into effect in that way, but the agreement makes no provision for what is left then.
I'm sorry, but in the meantime, why is it not appropriate for the court to make a declaration as to the existence of the agreement?
With caveats, my lord, the court will have now to rewrite that agreement in a way. Just as we are asking that the will be rewritten, just as they are asking that the will be rewritten, the court will have to grant a declaration on the document itself. But the court will say, well, yes, the Miami property, as the agreement says, will be given to you, but only if the Miami property remains as the Miami property after the executor has paid out all the debts and all the other expenses and whatever claims they may have against the estate.
Is there anything in Trinidad and Tobago that prevents someone who is named as an executor in the will and is awaiting a grant of probate from advertising for claims and indeed making the relevant title inspections?
Well, he will do that when he becomes executor.
No, I'm asking, is there anything in the law of Trinidad and Tobago that stops him doing that before he becomes an executor?
Well,
so that he can find out up front what he has to pay out when he becomes an executor?
That would only be, we have no provision for that.
Well, is there anything that prevents it? I mean,
except that he
is the deeds registry, where he would want to look to see if there are any encumbrances on the title to properties, private, or can anybody go and inspect it?
The deeds registry, my lord, no, the title searches can be done.
Right.
Title
so there's
searches
nothing to
can be
stop
done.
him making the title inquiries to see if there are charges and things against the property.
Right. That can be done.
Right. So what's to stop him advertising for debts? Advertising for claims?
Well, I do not know that there is anything that could stop him from doing it, from advertising. But
and if an executor is facing anything up to 5 years before he gets his probate, he would want to do that, wouldn't he? So he knows what he might be letting himself in for when he finally gets probate.
Oh, that, yeah. No, I understand what my lord is saying, and yes, it seems to be a practical way and a sensible way of doing things, because if even he as executor, probate is not granted to him, while he's executor, he has certain powers, but he cannot divest any property during that time. until the grant is made.
But Mr. Sunak, just following on my Lord Kitchen's point, it would appear to me that your submission now is the submission that even if these agreements were valid, there's still some problem with them.
Yes, but we have said that in submissions to the High Court and the Court of Appeal.
Right.
Is it pleaded?
That you will be declaring an agreement valid now, but you cannot put it into effect.
Yes, but that's the essence of it, isn't it? Your point is that it's impossible to distribute the assets in accordance with the agreement. But my Lord Kitchen's question was whether there's anything to prevent the court making a declaration as to the validity of the compromise agreement.
Because they will have again to alter the agreement and to make the agreement cannot be enforced as it is without certain other information being.
We're not talking about enforcement. We're talking about the court making a declaration as to the validity of the agreement.
Yes, my lord, but if you make a declaration that the agreement is valid, then it means that the agreement which says to give Blackacre to the appellant or to give Whiteacre to one of the children, that is valid, because the agreement says that. But assuming that that cannot be done,
it may not be possible to carry out the agreement in accordance with its terms. But that's a separate issue.
But how are we going to do that, my lord? Because you will have an agreement that you say is valid. But on the other hand, you say, well, it is valid, but you cannot get what the agreement says.
Well, the alternative, which, as I understand your submission to be, is that one can never decide anything.
No, my lord, but if you have an agreement that is valid, it must be provisions in the agreement that can be carried out, obligations that can be performed.
Subject to the usual steps that an executor must take in giving effect to any agreement, or indeed to the will, which is to discharge the relevant debts before making a distribution. At the moment, I'm puzzled as to why an agreement is a declaration as to the existence of an agreement is any the less effective than the will itself would have been. One can't give effect to it, perhaps, without knowing what the relevant debts are that one has to take into account as an executor. But that doesn't diminish the value of having one particular issue resolved, and particularly so when the judge has heard all the relevant evidence.
Well, I will come to that aspect of it in terms of whether all the evidence was there and there is sufficient evidence upon which can be made. But I'm saying the practical difficulties that you will have is that if the agreement, and the agreement does say what to do with specific properties, and that may not be possible.
Well, there could be another point, and that is that if you have a valid agreement, and by virtue of the fact that somebody has broken it and has thereby increased the debts to the estate and thereby prevented its application, the person who broke the agreement should be responsible for that.
Well, I think that would follow.
Yeah.
I think that would follow.
So there would be...
Likewise, the holding up of the grant of probate of this estate, and children who for some 14 years haven't been able to touch a penny, and they are living in squalor, poverty, and we have the appellant who is occupying one of the properties, but the children are getting nothing. That also, somebody will have to be responsible for that.
And just to go back to my Lord Briggs's question, at a slightly anterior stage, I understand that the putative executor applied for probate. Caveats were entered, a warning was given, and an appearance was entered. I also understand that the next stage in the process is for the putative executor to bring contentious probate proceedings to prove the will. And that wasn't done.
Either party can, my lord. Either party. The executive can do it,
sorry, I'd just like to ask the question.
Yes.
Why did your client not do so?
Well, the executor did not take it upon himself to go to court. Remember, this is an onerous job that an executor has. He's taking on a responsibility, and in most cases, without any remuneration whatsoever. You don't do that. So why is he going to involve himself in a court battle? And if the other side that has that equal opportunity and right, and they want to go to court, then he will have no alternative but to defend it. But if he takes steps on his own, then he takes the wrong steps, he will be liable. But it is something that, as I say, either side, after the warning of their parents, either side can take steps. So I don't think that is an issue here. That appears to me to be a non-issue, because the other side, having made a claim, they can go to the court. And how they went, we went through that as to whether it is contentious probate proceedings or whether it is making a claim in a civil claim. And bearing in mind that from the moment the caveat, the application for probate was lodged, and even before the caveat was lodged, there were letters passing between the appellant's lawyers and the executor's lawyers, and this has to be very clear. Mr. Nibar was appearing on behalf of the executor. He only became involved with the beneficiaries after the claim was filed.
That's not the evidence, Mr.
My friend made the point that his involvement was way back, and he asked Gina, when did he become your lawyer? She said, after my father died in 2008. When? Was it 2008? Was it 2000? According to her evidence. You cannot read into that after my father died, and my father died in 2008, he became my lawyer. That doesn't say it was in 2008. But we have to go by the official records. You are not a person's lawyer in the loose sense. You become a lawyer when you have accepted a retainer and you are doing legal work on behalf of the person. And the letters, my lords, it is somewhat tedious to go through reading them, but I have some notes. The very first communication was after the death. A certain lawyer made inquiries because the will, by that time, the existence of the will was made known shortly after the death of the deceased. I don't think that is in dispute. Evidence has borne that out. So, inquiries were made of this lawyer, of Mr. Nibar, who had prepared the will. And he said, yes, there is a will, and he gave him a copy of the will. Now that is before any application or advertisement. But subsequently there were letters, and the first of the letters that went to the appellant's lawyers was in 2009, or 2010. And this is at 0137, and I think it's important to look at that letter. And this was a letter from the executor's attorney, that is Mr. Nibar, written to Ms. Jairam.
Did you say 137?
137, my lord.
There's the wrong document.
I'm afraid so.
And that is 6th of October 2010.
No.
Pardon, my lord?
Our page 137 is a caveat.
0137. What do I mean? Yeah, it was after the caveat that was lodged.
I'm sorry, that page is in fact the caveat.
Pardon, my lord?
The page you've given us is in fact the caveat.
If you look at the bottom right-hand corner of the document
see.
you have,
There must be some
what page
error.
numbers does it say?
No, where is it? The caveat. Their lordships.
No, it's not the caveat we want, it's the letter. It's
The letter, yes.
Yeah, but it's not at page 137. If you look at the bottom.
This is the record that I have.
We're looking at the electronic page reference numbers.
Yeah, my lord, it's the same.
No, we're looking at the electronic.
No, electronic page. That's the hard copy. You're looking at hard copy page 97, right?
No.
No, you're not.
No, it also has a page 101, and I think this is how we have been working with it, so we would have been misleading the court all the time. We have page 0137. If my friends could help me find that letter of the 6th of October 2010.
101.
But may I read the letter, please, my lord, and I can provide you. That's the only other document. If I may be guided, please, my lords, I have 4 bundles of the electronically filed documents.
I haven't used paper bundles for nearly 3
And
years, Mr. Sewell.
at the bottom of
Go on
each
screen.
page, Platan, this is the electronic bundle.
This is the recent record, that's the electronic bundle, October 6th.
It's a page it's a page 139, I think.
Is this a letter of the 6th of October?
Yes, please, my lord.
139.
All right. That's the document, and it is to the appellant's lawyers and re-estate of Jairam deceased. I act on behalf of Dr. Ramraj Deonarine, the executor named in the will of the deceased, of caption, probate, which is in process. I refer to the caveats, and then it says, today, Mr. Bobby Khan visited my office, informed me that he represents your said client. He further informed me that the children of the deceased and your client met and agreed to an amicable out-of-court settlement of all matters concerning the estate. So the letter is not on behalf of the children. And I would appreciate if you would communicate with your client on this matter. I would also communicate with mine, and that would be the executor. In the event there is an agreement, I suggest that the terms be documented and executed by all parties. This is in October of 2010. Kindly inquire from your client whether she is able to provide any information concerning, and this is at the stage where the executor was collecting the estate for the inventory. So at this point, it is quite clear from this letter that Mr. Nebar was acting on behalf of the executor, and he is getting information from a third party that there are some discussions going on. So to say that Mr. Nebar was involved, according to my friend, at an early stage in 2008 to 2009, up to this time he was not acting on behalf of the children, the beneficiaries. Then, subsequent to that, we had other letters, because having made that inquiry, It shows the willingness of the lawyer. If you have agreement, then let's deal with the agreement. Why would you want to go to court? That's our duty or responsibility to try to have matters resolved without going to court. Then we had a letter on the 10th of May of 2011. We moved from 2010. And now, which page would I say that is?
143.
I have 141, so if it's 143, and it says, your client, acknowledge receipt of your letter dated 6th of May, because by then we had 4, 5, 6, 7, I think we had letters, caveats and so on. And for the avoidance of doubt, please be informed that in my oral conversation with Mr. Sina Jairam, SC, I informed him that I had heard that Terence Sijatan, son of the deceased, agreed to share equally with your client the monies he is entitled to receive from the proceeds of the sale of the estate. And this is hearsay. In that conversation, I also informed Leonard Senior that I received no confirmation of same from any source, and I suggested that Leonard Senior should confer with your client on the matter. The conversation with Leonard Senior took place since December 2010. Nothing has since happened except that when I telephoned Leonard Senior on the matter in late March 2011, he informed me that he would be leaving the jurisdiction on April 8th and would send me a proposal before that date. Up to the present time, I've received no proposal, nor did I receive any information regarding the said matter. As such, I took steps to file and serve the warning to the caveat. This was after 3 caveats, trying to avoid litigation. And of course, there was a threat. I don't know if I missed out that page where, yes, I will come to that. So even up to this time in 2011, Mr. Nibar was not acting for any of the beneficiaries. So and he's saying, I heard that there are things, not that he saw any document. So how could the allegation be made? Well, of course, allegations can be made anyway. How can you substantiate that he had documents that he could look at? Drafts of agreements or anything like that. It's totally wrong to suggest that. And then we had a letter where's the date of this? Yes, I'm looking at a letter, I'm not seeing a date on it. The binding is a bit of a problem. Give me the letter.
Well, there's a detailed reply to it on the 26th of May on page 145.
The letter that I am looking at says, we acknowledge receipt of your letter of 10th of May 2011. Yes.
Yep.
As you can appreciate.
Yes, that's page 145.
Yeah. And this was a letter now from the attorneys for the appellant. And it is, suffice it to say, if this matter becomes contentious, as you have intimated, then our client may not settle for 1/5 or 20%. So this tells you that this was, in fact, a conversation taking place between an offer made by Terence the son to give the 20%. This is an acknowledgement of that. But without Mr. Nibar anyway, if there were other lawyers, we wouldn't know. But without Mr. Nibar, we may not settle for 1/5 or 20% of the estate, as was suggested by your good self.
I'm not quite following, I'm sorry. These letters are anterior to the actual agreement.
The agreements, yes. Yes.
And they don't involve a concluded binding agreement between any of the parties. The only allegation is there's a concluded binding agreement in what are called the compromise documents.
Yeah. Yes, yes, I.
And your client alleges that the compromise documents are fraudulent.
Yes, and
Yeah. Who committed the fraud?
pardon, my lord?
Who committed the fraud?
Well, my lord, the documents were prepared by a lawyer. The documents were prepared in Trinidad, and I have no information beyond that.
Okay, so a lawyer produces documents.
They went for,
Do you accept that the documents that we have, which are signed, are the same as the documents that were produced by the lawyer?
in the case, yes,
this
my lord, in the case.
You accept that the documents, which are termed the compromise documents, were in fact the documents that were produced by the lawyer?
Well, in the record, that's all we know. They were
So
produced.
who committed this fraud?
But Lord, I'm saying that the documents were prepared in Trinidad, and I do not think there is any evidence contrary to that. The documents were executed or sent for execution in Florida. That's as we know.
And so,
In Florida.
and therefore the document that is produced in Florida must be different from the document that's produced in Trinidad.
Pardon, my Lord?
The document that was signed in
Florida
must therefore, by definition, be different from the document that was
That in the normal course of things should be.
right. Okay, and then the person who produced those documents in Trinidad would be fully aware of that.
Ought.
Yeah.
Ought, my Lord,
Yeah.
yes.
So,
But
well, it's a somewhat
it's a serious allegation, I know.
well, it's a serious allegation against lawyers.
Yes, I know.
And do you make that?
Well, my Lord, we
And
can...
if so, on what evidence? Because in order to plead fraud against people, one
Yes,
actually needs
must have
evidence.
particulars, yes.
Right, okay.
All right. I'll go straight to a document now which should help us in our work. From the evidence and from all the submissions, you realize that there's a lawyer by the name of Farbstein who was in Florida. The allegation is, on the other side, that Farbstein gave legal advice on the document. The pleadings are in effect saying that, and the witness statement, and now this is the person talking about the appellant, in her witness statement, I'm going to try to get it for you, where she is speaking to the compromise documents. And 308, witness statement, the witness statement. In the witness statement. Which is the witness statement. So we agree. And we had the reply. If I may go back, my Lord, first of all to the question that was asked about particulars of fraud that you will have to give, and that would be in the Respondents document. Defense of the co-defendants. In the defense of the co-defendants, on my electronic page is 271. So it may be somewhere in that vicinity.
Soon. 340.
Always add 2 pages and we'll be there. 273.
273.
Yeah.
So perhaps I will try to use that to help me. And in that, it was specifically pleaded that after setting out different steps that were taken, we go to paragraph 17.
Yeah.
Yeah.
In response to 17, 18, and 19 statement of claim says that on about in the year 2011, claimant represented to them that the Miami business had no money to pay the arrears of taxes on the Florida properties, and that she would pay same, and withdraw the caveats. So this was a scenario where the estate was in trouble because they had taxes to pay. The businesses that were being run by the appellant. That is the person who had the purse strings and all of that. And this is a precursor apparently to the agreements that were made. And we're not saying that there weren't agreements. There was not agreement. We're not saying that. We're saying there was an agreement. But this is how it came about, and she would withdraw the caveat. So if she says that she would pay the taxes and she would withdraw the caveat and do nothing further to obstruct or impede the probate of the will and distribution of the deceased estate if she would get the property situated at SW11 Place and so on. Where she resided, and also 20% of the proceeds of the sale from the Trinidad properties in full settlement. That it was agreed that Terence would get the Hollywood business, execution of all the other properties. This is, in essence, the agreement that the beneficiaries are saying that they entered into, and for the reasons. Reasons why? Because they could lose everything, and they'd say, okay, this is what we will do. That within a few weeks of the making of the oral agreement, claimant brought a few copies of documents, each consisting of a few pages, which Terence, the third and fourth, signed. Same was consistent with the oral agreement.
So where are you reading from now?
And
Sorry? Paragraph C.
That's C.
Thank you.
Yeah.
Yes, got it.
and then paragraph D, the agreements they signed did not contain anything to the effect, one, that the claimant resided with the deceased in a common law relationship or words to that effect. Two, the claimant be appointed legal personal representative of the deceased estate. Three, that Dr. Deonarine be removed as the applicant for the probate. And four, that any of the Trinidad properties or any part thereof would be transferred or conveyed to the claimant. And specific denial that they signed any agreement or document or paper in the presence of Dr. Harry. We heard my friend read out the evidence in which they said a document was signed at the store. And then they deny ever having the benefit of independent legal advice or any legal advice at all regarding any matter concerning the individual or collective interests in the estate of the deceased prior to seeking the advice of Mr. Nibar. And there are the particulars of fraud here, which is at paragraph 24, substituting or replacing the documents, and of course, this is a question being put squarely to me. Who did that? If a lawyer prepared a document, then by making an allegation like this, it's either that the document prepared by the lawyer was not the same one signed, but the lawyer presented that in the case, so it would follow that it is the same document. And willfully...
Sorry, I didn't quite follow that. Sorry. Could you repeat that? Sorry.
I am saying, my lords, that an allegation like this, that they were not, it was not the same document. It means that someone substituted the pages. And the question that was asked by my lord, as to who committed the fraud.
But the person who prepared the document must therefore have known the pages were substituted.
Because he presented it in the case, yes, and I'm accepting that.
Are you making that case?
I'm saying, my lord, this is the evidence that you have, this is the pleadings that we have. And these are the particular...
May I know it's unusual, but I'm afraid I can't restrain myself. Learnfeld is making an allegation implicating me in fraud. I asked him at the trial. I said I offered to take off my robes. This is the document I prepared. These are the documents that were returned to me, and I caused them to be registered. It is the first time he's saying, the third bite of the cherry, implicating me in fraud. That is not fair to me, my lords. My learned friend knows, if I may say so myself, I have an impeccable reputation at the bar. In the Caribbean, I've been practicing law for 44 years. And that is something very grievous, that he's making an allegation in the twilight of my career. And I've been a senior counsel as long as my learned friend has been, because we got served together in 1998.
Mr. Jaram, I don't think we're going to be assisted at all by allegations on either side being made at this late stage of the proceedings. We're anxious to obtain the assistance of all counsel in the case in order to try to establish whether the Court of Appeal whether the Court of Appeal was correct in coming to its conclusion that the judge was right not to decide this issue. And that is the matter on which we must focus.
I'm obliged, my lord, but you know, it is not a nice thing for me to learn fantasy at this stage. And these proceedings are being looked at worldwide.
Yes, Mr. Sarda.
Lord, I am only going by what is here, and I accept that it is a serious allegation on the pleadings. These are the instructions.
The point that I was making was that it's an incredible allegation to make.
Well, I don't think so.
In a situation where you had previously sought to implicate the lawyers involved.
Previously, on the pleadings, they're there. I cannot get away from it. I have to go with the pleadings. So I am not now making an allegation against my learned friend, who is also my personal friend. I am not. It's here in the document. If we might try to ignore it now, my lords will see it is there. They're there. But according to our instructions, they signed an agreement. The pleading says so. And I will go back to get the reply from the appellant's reply. There is an agreement at page 308, maybe 310, my lord, I'm not sure. An agreement is attached. And I'll show you where the appellant herself is relying on that agreement. But this is in the pleadings of the co-defendants, who are the children. And that agreement says, agreement made and entered into this blank day, but it was in the year 2011, by and between appellant and the children, you will see there. And it says here, whereas the parties, that is Lauralee, the parties except for Lauralee that is the appellant. Apart from her, the others are the heirs of the deceased. And sorry, in the US they call them dissident. They are the heirs. But what is interesting in this, whereas the dissident died intestate, and this is in 2011, when the caveat was filed in 2010, when the application was already made, in 2009. So this agreement here, the lawyer in Florida is saying that was intestate. And the parties have agreed to the distribution of the estate. And you would see here, it is in keeping with what the co-defendants are saying. We agreed to compromise. We want to have this estate settled. We want to have this caveat removed. Don't tie up the estate. And this is what we will do. And this was signed. And this was signed in the office of Mr. Farbstein. And it was signed by the appellant and all the children. And she put this document initially into her reply to the co-defendant's defense. So it's not a document that we are making up. But what is important about this document is, this is the only document that was signed before Farbstein, according to us, and according to Farbstein. And the allegation that she was making in the reply, that they had independent legal advice, and they were adults, and they knew what they were doing. This is the document. No other document. And this is why they are saying, well, this is a document we signed, not a document that we subsequently saw coming into the pleadings with so many pages. That is their evidence. Get the reply for me. So in the face of that, my lords, what is a lawyer to do? Tell the clients that no, you cannot make that kind of allegation, but they are showing you their proof. It's for the courts to decide.
Well, I think actually before counsel puts an allegation of fraud in the pleadings, it's for counsel to form a view about it.
But somebody has to do it, my lord. If the lawyers, if you get instructions from your clients that there is an offense, something untoward was done by your colleague, you cannot say, well, that's my colleague, I wouldn't do it. That is not our oath. So I accept it as a serious allegation, as I said. I'm not denying that, but I'm saying in the light of this agreement that was signed, and in the light of her pleadings in her reply to this defense, my lords, she has relied on that document. And she's saying that is the agreement, the compromise documents that were signed. That's what she's saying. All right, then let me get the LR1 is in that. The reply 379, maybe, my lord. Reply to defense. The defendant. No, this is not a defendant. The co-defendant's defense. Get it. No, it wasn't. Where's the LR1 boy? LR4. I want to go to the paragraph in which she refers specifically to LR1. Yes. Page 18. Paragraph 18 of the reply, which I have at 387, maybe 389 on the record.
Well, it's a very long paragraph, but it starts on 304 and goes on for a couple of pages.
I see, yes, with a lot of... but at paragraph 18, which says, the children of the deceased and the claimant had agreed that the estate will be distributed with each of the children and the claimant getting certain assets. And further, in consideration of the claimant paying outstanding taxes owed to the various properties on the payer's properties in Florida and for paying for repairs to the Miami store and to liquidate certain credit card bills, the claimant will receive all the lands in Rio Claro hereunder and rely on the particulars set out in support and or justification that of the fact that the agreement between the children and herself for distribution of the deceased estate was voluntary and freely entered into with the benefit of independent legal advice. And you recall that the Court of Appeal is saying advice is one thing, independent legal advice is another.
Just while you're on that point, why legally should that matter?
Pardon, my Lord?
Why legally should it matter whether there's independent legal advice?
Because the relationship between the parties, there are certain things which, like when a court will require corroboration, but to ensure that the parties, against their interest, it's like going to a bank and one party is mortgaging his interest, but he's not a borrower. The other party is borrowing, but the property belonging to both is being held as security. That is the property that's being mortgaged. We do it there, and I'm sure it's the same in the English law, that you get independent legal advice. You know you are pledging your property here. You lose this property, you are not borrowing.
You get independent legal advice when there's a relationship, presumed relationship of undue influence. This doesn't fall into any category of undue influence, relationship of undue influence.
Well, my Lord, remember we're dealing with their children, and they are the beneficiaries.
No, but they're not children. They're not children.
Pardon, my Lord?
They're not children.
The children are not the beneficiaries?
They're adults.
They are not children, they're adults.
Oh, I see. All right, in that sense, yes. Well, that was a finding also of the Court of Appeal, and my lords are pointing out to me that it does not fall into that category. Yes, all right. But, okay, this is what the pleading says, compos mentis and all of that. And the particulars that she proffers here. An oral agreement was made between the children and the claimant about 1 month in advance, about September 2011, before they agreed to sign a binding legal document. That is to say, an agreement at the office of David Farbstein, Esquire, attorney at law in the state of Florida, a true copy of which is hereto annexed and marked LR1.
And am I right? LR1 is the document at page 310.
That is the document. That is the document. Undated and but signed by them. So this is put forward by the appellant herself. And this is what the children, now children, all right, the beneficiaries are saying, this is the document we signed. And it is in that context when you get instructions like those and say, we signed. This is what we signed. Yeah. Apart from this document, Farbstein letter. Apart from this document, my Lord, Farbstein had no involvement with any other agreement. There is no evidence. The evidence coming from the other side in this pleading itself. And when we go to the witness statement, which I would ask my junior here to find for me as well. The witness statement, that is the evidence now, not only the pleadings, that is repeated. What is in the reply is repeated in the witness statement of the appellant. So there can be no mistake about it. Witness statement 480, so that, my Lord, could be 410 or somewhere thereabouts.
480, is it before 82?
482. All right, yes, 482. And the first thing we did, and I won. Yes, it's a paragraph 4 of her witness statement, where she says, on or about 2nd of June 1994, Peter and I met and so on, and talking about other people, Peter mentioned to his relatives he and I had decided to live together and so forth. Attached, not the photograph, sorry my lord, these are photographs, but she annexed. When you find that document, I wanted to refer to other documents, which, to say the least, were suspicious. And I made mention of them. There are deeds and the affidavits by Harry, in which the deeds were allegedly made on the 27th of January, final deeds. And the affidavit of execution was sworn by Harry prior to the registration of a power of attorney from Laura to Terence. And I made mention of that in my speaking notes because it is obvious on the documents.
Where did you see that?
Where is speaking notes?
We have the speaking note. Which paragraph is it?
Yes. Yes. Yes, at paragraph 4, I was referring to the power of attorney, and I have 0160. 0160. And what I noted there was the signing of the document is noted as the 25th of January. And a statutory declaration, which is Part B.
So what page do we find the statutory declaration at?
Pardon, my lord?
Where do we find the statutory declaration?
Yes. At 169, has to be 71 then?
Let's try.
16171.
171, yeah.
Statutory declaration. Is it Mr. McBride?
So this is a declaration that was signed in March. Yes.
So this,
The A, as you would
the
notice.
power of attorney is dated the 25th of January 2012, and he declares that he was personally present on that date
Yes.
when it was signed. Is that right?
And
And then what's
it was signed in March.
what, the statutory declaration?
Yes, it was subsequently saying that he was present on that date.
But if you look at page 171, he solemnly and sincerely declares as follows: I was personally present on the 25th of January and did then and there see Laura
Sure is the one.
party to the instrument purporting to have power of attorney.
No, that is.
Signs.
Yeah, but it's in the 25th of January.
Well, I mean, the next document to page 172 is somebody actually authorising or formalising the document at page 171. All that's happening there is that a notary public is saying that Sean McBride has made the statutory declaration.
What the notary says, the deed is dated the 25th of January, and he's saying the declaration was made on the 25th of January. Yeah.
So, the power of attorney is dated the 25th of January. The person who witnessed it gives a declaration on the 5th of March to that effect, and somebody actually, a notary public, certifies that he gave that declaration on the 5th of March. There's not much of a conspiracy there.
I will have to. Yeah, no, but I think what my energy is pointing out to me is that on the document itself, where is, this is A, the document is marked A. And the document says, this is the deed marked A referred to in the next statutory declaration of Sean McBride, declared before me on the 25th of January 2012. Sean McBride swears this affidavit on the 5th of March 2012, declared before me in 2012, January, and it is saying here, this was sworn on the 5th of March.
No, he's saying that the statutory declaration took place, and
Yeah. More than that. But this is only one of a few of my
and was this investigated at the trial?
But no.
Was this investigated at the trial?
Yes, we put forward to the court, and this is why I'm saying that there were things that were raised in the trial that were not fully investigated, and therefore, and the judge made no mention of them. How could you arrive at or make a declaration that these documents which form part of this compromise document or compromise agreement, how could you do that without making mention of these things? They're small maybe. But somebody was supposed to answer these questions. Then get on the affidavit which says it was registered in March 2023. So, from our perspective, my lord, we were saying the power of attorney is not the same instrument referred to in the declaration of McBride, because he's swearing in March. Now, it could have been an error, because they were dealing with several documents, but it is something that has to be explained. Then I went and dealing with the agreement in particular. And again, it is 0174, it might 176 to 20206 would be. And this is a reference to the document made on the 27th of January 2012. The deed number D 2012.
Sorry, what page number? Sorry, what page number again?
My lord, I
176.
thought it
Thank you very much
was
indeed.
0174. Is it 0176?
Yeah. Thank you very much indeed. Thank you.
Yes. My lord, Briggs has been helping me out there.
No, yes.
You are lost as well on it.
No, 173.
I have 174 to 2004. These are the documents that we were talking about, compromise documents.
Yes.
176. Sure.
176.
And we're talking about the deed registered as 2012-006-14096. And that is the agreement of arrangement, settlement, and compromise.
Yeah.
That's the heading of the document.
Yes.
Well, that starts on 176.
Yes.
Yep. Obliged to you, my lord. So it's 2 pages down.
Right,
Yes.
so what's the point?
The point I'm making here is that this deed was issued by the Registrar General's office on the 13th of March of 2012. That is when the document was registered. And this deed was not in existence on the date of the purported execution of the deed.
I.e. the 27th of January 2012.
Yes, my lord, 27 January. This deed. And you would note that the affidavit, there were blanks.
Where are you looking at in particular?
Look for the document there.
I'm sorry, I'm not understanding this. You say that the deed was registered on the 19th of March 2012, and you say it was not in existence at the date it was purportedly
The 13th of March, yes.
on the 27th of January. Is that right?
Yes.
That was the submission.
That was the submission.
Was the other one that Harry was saying? You see, in the absence of these persons, it's not absolutely necessary, yes, you call the evidence that are available to you at the trial. But Harry, to my mind, and to us, was an important
I'm sorry, Mr. Sonath, what's the submission that you're making in relation to the document on page 176 of the electronic bundle?
This is a document, not a document. Give me one moment, please. Let's see.
Well, your speaking note at page 4, paragraph 7, seems to refer to the deed of the 27th of January 2012. And at letter A, it states, the date of memorandum of identity was tampered with prior to registration and not initialed. I'm not certain who it is alleged tampered with it, or how it was tampered with, or what the tampering was, and what the significance of the date being changed or not initialed is.
Well, it's only to show that the date was tampered with.
So what? I mean, the deed is dated the 27th of January 2012, and nobody, as far as I'm aware, suggested at the trial that the deed didn't exist. If it was one of the compromised documents. I'm afraid I'm struggling to find out what the submission is about
I
this.
can see it's difficult. Let me refer to another document, and then I'll get back to you.
Yeah.
This is the one talking about it. Give me the one that shows the insertion of the affidavit. I think I might be on firmer grounds with you on paragraph 9. We were referring to the deed of 2012-0055-8003, and that is the certified copy. Right. Look at the affidavit. Yeah. Mr. Harry
You see, I mean, this is all against the background that at the trial, it was accepted that the power of attorney was valid by the witnesses.
Well, I don't think it is correct to say it was accepted. The power of attorney was put into evidence. We always queried the issue, and we made submissions on this at the High Court level, on this very point. That Harry was saying that there was a deed that was registered, which could not have been registered at the date of the registration of the deed itself. He was referring to the authority, the power of attorney, that he was saying was registered on a certain date in his affidavit. But that power of attorney was not yet registered. So somewhere, somehow, this number was put into the affidavit.
Well, Mr. Sonath, as I understand it, you're alleging that there are inconsistencies in the dates to be found in these documents. But for my part, I'm afraid I don't understand the submission that's being made. And the difficulty is that you have less than 10 minutes of your time left.
All right,
and so it's a matter for you as to how you use the remainder of that time.
Yes. Yes. All we are saying that there's information in the document that could not have been correct because at the date that information was not then available. My lords, at paragraph 17, I refer to some observations that can be made, and this is the non-disclosure by the appellant in her pleadings initially that she was lawfully married to Terence. Now, it is only when we raised it that she had to make a response and admit that she was married to Terence. And her only explanation was that she was forced to do it because the deceased didn't want to get married to her. No other reasons were given why he wouldn't do it. But the fact is that there was a lawful marriage. The fact is that the deceased had bought a property in the name of Terence and the appellant, not in his name and the appellant, but in the name of the son and herself, who were then lawfully husband and wife. My Lord, you will notice that when she went to make the application to become the LPR of the properties in Florida, there were inconsistencies. She did not say she was a lawful wife. She said she was a friend of the family. She said she was a creditor, and on that basis she was claiming to be there. And this all goes to the credit of the witness. And these are matters that were raised. For a court to deal with the evidence of a witness like this, there would have to be some reference to that, to say, well, these are mere inconsistencies, but it doesn't go to the root. Something, my lords, can make that finding as well. I don't deny that you can. But I'm saying these are all matters that were not dealt with by the trial judge. She did not address her mind to any of these issues because she had already decided, wrongly it would seem in my Lord's mind, that...
I don't smile at all.
But my Lord, I'm saying that whether she should have dealt with the agreement, make a finding on the agreement, but she had already decided that she's not going to make a finding there, and she did not deal with these issues. And this is why the Court of Appeal said, well, there were not findings on any primary facts for us to make a finding. So I do not think that the Court of Appeal was wrong in that sense, that if you're asking us to make findings, there must be findings of fact from the court below, and based on those findings of fact, we may be able to say we can make these findings. So I do apologize if I use the wrong term, but I know the question of why can't you make a finding on the agreement before the probate? And it is in that context I was saying, and this is why the Court of Appeal said, both courts, well, you deal with that at another time. And I saw reasons why there would be practical difficulties in not waiting for the probate and implementing the agreement that the appellant is asking this board to deal with, and to say that it ought to have been decided by both courts, and of course asking this court to say, well, you can determine that because there is evidence on which you can do it. My lords, it is not an easy issue, an easy question, but when one looks at the relationship between the appellant and the children and the family as a whole, she was an integral part of that family. She grew up, some of the children, they are now adults, yes, but they were children in school, and she grew them up as a nanny, as a housekeeper. And of course, she went beyond that to say that she was the common law wife. But that in law could not at all. In our jurisdiction, once we had the Cohabitational Relationship Act that was passed because of these difficulties of common law relationships. That is how we came to pass the Cohabitational Relationship Act. So it's either you're there, cohabitee, or you have no rights. You can come in trust if you want to. And in the case in trust, we have shown that it was not pleaded. We made that point, and we pleaded to it as well. And when it was raised in the submissions, we replied to it. And therefore, the Court of Appeal, in our submission, was correct in saying, well, you did not plead any trust. donatus motio causa, and all of those things, or a resulting trust, which is in the same vein as common intention trust. But there was no basis whatsoever for, and there wasn't sufficient evidence for the court to make a finding, that is the court below, on common intention trust and giving her a 50% interest in a large estate. No, and I don't think they pressed the point, but she did not have the evidence sufficient to be declared a cohabitee under the Act. I don't think they could press that point at all. But remember, the bulk of her claim seems to be based on that. I was a common law wife, and I did this and I did that. She went there in I think it was 94, she went, there is no evidence that she walked with a penny. That is not her case, that I went into a relationship and I had property of my own. She went there, she admits she looked after the children, she admits that she helped in the businesses when there was time, and she admits that she was in charge of the properties in Florida while the deceased was in Trinidad after he had been deported. But in terms of showing money that she brought into what we would say the relationship that they had there, whatever it was, that she brought anything with her, there is no evidence. But she worked within the business, and whatever she earned there, and the children in their evidence made it clear. Yes, she sent money to Trinidad while her father was there, but it came from the business. She bought airline tickets, it came from the business. So not that she would have been entitled to nothing at all, that she had food, clothes, shelter, and all of that. But to say that there was sufficient evidence of contribution which would result in a resulting trust by virtue of contribution, there is no evidence of her own money being put into anything. I am there, my Lord.
I think you're there.
That's it.
Thank you, Mr. Sana.
Thank you very much, my Lord. Thank you for listening.
My lords, I'm grateful.
Mr. Jada.
Much obliged. I start where my learned friend almost ended, on the power of attorney. That's a classical trial by ambush. The pleading of the first named respondent at paragraph 15 of his defense, he admits the power of attorney, and the reference is EB 0269. Insofar as the pleading of the...
Sorry, paragraph?
15.
Thank you.
EB 0269, he admits it, unequivocally. Gina and Lisa said at paragraph 14 of their joint defense, they make no admission to that power of attorney. Parents were silent. And that's reference is 0279. But we have the clear evidence of Mr. Terence Sijatan at EB 1242. Midway of the page, I ask him, do you accept that the power of attorney which was given by your sister Laura to you is valid, at least as between yourself and your sister? Yes, sir. And I said, thank you. So, and insofar as the power of attorney is concerned to my Lord Stevens pointed out is Sean McBride at EB 1240 at the bottom of the page. I asked Gina, do you know the person Sean McBride? Yes, who is he? That's her husband. My lords, those references should put the nail in the coffin as far as the power of attorney is concerned. The fact that it was deposed to the statutory declaration 25th of March is no moment. It's the date that the parties agree that will take effect. So that's the first point. Coming back to when my learned friend spent about half an hour, we submit that those difficulties he alluded to are imaginary. If there are debts and taxes to be paid, clearly they have to be satisfied before any distribution. The compromise documents will be subject to the laws of the land. My Lord Stevens asked for learned friend. Well, there were advertisements. Yes, there was. Was there any response from any creditors? The answer was no. So, firstly, those debts will be statute barred unless there are specialty debts like mortgages and so on. And in any event, my lords, whoever is the executor will seek directions of the court. No distribution can take place in specie if legitimate debts are owed by the estate. I don't know why Millennium Fund has gone on to a dissertation telling your lordships. But importantly, you know, my lord, it was not pleaded in their defenses that there was any difficulty about enforcing the compromise agreement. The sole defense that was pleaded, a two-pronged, is fraud. And the fraud was that the pages you produced are not the pages that they signed, and secondly, there was no independent legal advice. So, surely, my lord, civil litigation can't be conducted by, like trial by ambush. You have to tell us what you're coming with so we know what are the issues. And the executor, my lord, if he feels he personally has difficulty, it happens all the time. Renounce your executorship. Let somebody else take your place. That's as simple as that. And I ask you, when you look at the inventory in the application of probate, no debts are listed. And that reference is EB0118, EB0118.
Sorry, the reference again, please.
Sorry, my lord. I'm going too fast. I'm conscious of my time.
No, can I have
0108 to 0118.
Thank you.
And that's the inventory.
Yeah.
Now, my letter friend, Mr. Libar, wrote a letter, 0779, and it's a two-paragraph, 11th of July 2011. This is in response to my learned friend when he was trying to come to Mr. Libar's defense. We could only go by the evidence, my lord. Gina said he was consulted or retained in 2008. That's what she said.
And the reference again, please?
0779. Mr. Nibar is writing to Ms. Jairam on the 12th of July 2011. I refer to the proposal contained in your letter dated May 26, 2010, made on behalf of your client, Ms. Lauralee Ramcharan. I am instructed to inform you that the said proposal was rejected. Millennium will have your lordships believe that it's only when this claim was filed on the 19th of April 2013 that Mr. Nibar came into the picture for the children. On the record, that doesn't seem to be right.
Just the lack of any debts, you gave a page reference of 118.
Oh, sorry, my lord. 0108.
Sorry, 0108.
To 0118, 118. And that's the inventory. Mr. Nibar was replying to Ms. Jairam's letter of the 26th of May, and that's a reference 0145, Ms. Chantal Jairam's letter. So that at least, my lord, quite apart from the evidence of Gina, who took an oath to tell the truth, Mr. Nibar has it there in black and white. I'm instructed. Well, it can't be. By instructed by whom? He's instructed and he rejected proposal. My lords, I will leave the question about, as we all know it as law students. If you're going to plead fraud, you must have instructions. You can't come here, and that is why I apologize, my lord, because I was upset. I asked Millennium Fund this trial, and they were clear and specific that they were not attacking me. But he is leaving it, and my Lord Stevens was asking him questions, as though that I was complicit in the fraud, that I substituted papers or documents. And that is the extent to which these respondents will go to.
Well, he's withdrawn that allegation now.
Huh? Oh, yes, I should have said, my Lord.
My Lord Stevens.
I said their statute bar.
Made the observation that that allegation has now been withdrawn.
Thank you very much. Now, my lords, very quickly, if I may, in paragraph 2 of my learned friend's case before the board, and that's at EB 1523, there says, following the appearance to the warning, the appellant filed a claim. The way it is put, as though with alacrity, we jumped into the fray and filed. 1 year and 9 months had elapsed, and the executor wasn't doing anything. He was suffering from some kind of paralysis. And since we had in our possession these compromise documents, absolutely nothing was wrong for us to move the court to get some kind of relief. I said that. At paragraph 3, the page over, this is like a recurring decimal. They keep throwing in, as though it will affect your lordship somehow, about Lauralee's relationship with the deceased. That door has been closed and bolted in their faces. The Court of Appeal in paragraphs 38 and 39 said that the High Court judge was entitled to find, it was a contested issue, my lord, to find that she was the common law wife of the deceased. And that's the end of it. I don't know why they bring it up here, because there's no appeal against it. No. At paragraph 5, Laura Valley, they will have you believe that it is named after Laura, the daughter. Far from it, my lords. Lauralee testified it was not put to her, this is incorrect, and the witness who testified on her behalf, it was not put to him either. The references are EB0491 and EB0719, that property was named after Lauralee, the appellant. My lord, and you will see in the cross-examination of Gina, they refer to Lauralee as Laura. That's her calling name. My friends can't be so loose with language that they are. And on page 5, electronic model 1526, at the top of what is paragraph 2 numbered there, they said we claim 12 relief. That's an inaccuracy. We claim 14 reliefs. And that is why the learned judge gave us just 1/14 of the costs. And so far, my lord, it is obvious we made the point at 1532. All we say, they had the burden of proving the fraud. He who alleges must prove. They have not come up anywhere close to it. And equally, my lords, lastly on the written case, on page 1536, my learned friends have stated in paragraph C, the influence which the appellant and her attorneys had over the Peters children. No undue influence was pleaded in the defense. And it seems as though they're plucking things out of the thin air and trying to persuade your lordships otherwise. My lord, and similarly, in the speaking note, I commented very quickly. This morning, we only saw it this morning. First point, I think I made that point this morning, but just in case my memory is, the points now being taken about the compromise documents were not pleaded. They accepted that they signed, but the registered compromise documents produced in the case were not the documents they signed. The fraud is pleaded, my lords, at EB0346. I've already told you about the first respondent admitting the power of attorney and so on. It seems to us, my lord, that they're changing the case in midstream. I dealt with the common law wife issue. That is not an issue that ought to trouble your lordship at all, because it doesn't bear on the compromise documents. She's not a lady who just came out of air from the sky. She was somebody. The stamp duty point, my lord, is irrelevant. All deeds or instruments to be registered in Trinidad and Tobago have to be presented to the Board of Inland Revenue for adjudication, otherwise the registry doesn't accept them. The revenue is stamp adjudicated, no stamp duty payable, or whatever ad valorem is payable. The stamp duty cannot trump. The stamp duty point cannot trump the agreement between the parties. That would be subject to the laws of the land. Nobody's trying to evade stamp duty. At least they didn't plead that it was illegal and unenforceable because they concocted this to defeat the revenue. So, my lord, it seems to us that the speaking note is a departure as well from the case. And for all those reasons, we say the significance of not putting or withdrawing the allegations of fraud of the compromise agreement to Lauralee means, and that is why I know Melinda Jr. is reluctant. I am reluctant too, my lord, because I've read cases, Davy case and so on. But this is not a case where there is conflict. You don't have two versions, it's only one version. So her, Lauralee's witness statement from paragraph 90, what's the EB reference? EB 502 to 509, they stand. And based on the clear cross-examination of Gina and Terence, your lordships ought not to have any difficulty in coming irresistibly to one conclusion, and that is that the compromise documents are valid and enforceable on the basis of what has been pleaded and on the basis of the clear, uncontradicted evidence. Why send it back, my lord? I ask of you, please, I know you don't want to encourage other appellants and litigants to come before you, but this case is an exception, and I ask you to do what is right, just, and fair. Those are our respectful submissions, and I thank you, my lord. It was an honor and a privilege for all of us to appear before your lordships.
Can I ask you just one short question, if I may? We're very reliant, the board, I personally think, is very reliant upon information given about really relatively mundane things.
Yeah.
Like how long does it take for probate to be granted in Trinidad and Tobago? So, I mean, I can understand that there may be a bit of a dispute about that, but I'd be very grateful for your considered view about it, okay?
Two things, my lord.
Yes?
Melinda Jr. was trying to communicate with the registry while you were asking the question.
Yes.
It is true all of us had COVID-19, but I promise we don't have an answer from them. They could take long because some of the clerks arrogate unto themselves powers they don't have and make queries. That's a fact. But this is a clear case where all the queries have been answered. There are no queries. And since 2020, the Court of Appeal says, go ahead.
I was just asking, basically, how long it usually took in a run-of-the-mill case.
My lord, I would say in this case, having regard to COVID-19, 6 months should have been the maximum.
Okay.
And since the registry has been closed, they encourage you to email rather than in-person contact. And my juniors are telling me there's a system of electronic filing in probate. So there is absolutely nothing, my lord, in the way of them getting this piece of paper and say, probate of the last will and testament. And Ms. Jairam is telling me, who is more au courant with that aspect, that the probate registry in Trinidad and Tobago is completely electronic. Searches and everything else. So I say on the outer limit in this case, having regard to the order of the Court of Appeal, there was absolutely nothing in the way to cause delay.
I have one question. Yes, of course. Well, two. You made the point, which is correct as a matter of fact, that the probate inventory submitted by Dr. Deonarine didn't include any debts.
Yes.
But my reading of it suggests it's only designed to identify the gross value of the estate. Indeed, there's a little bit in brackets saying irrespective of any debts, close brackets.
It is customary where their debts are known that they be put in to show what is the net value of the estate.
Well, no doubt.
Especially the days when we had stamp duty.
No doubt there'll be endless argument about what is or is not customary. The other question I had was simply whether a duly executed power of attorney can be acted on before it's been registered.
Yes, my lord.
Okay.
Yes. Because the deed takes effect from the date of its delivery. Registration is simply notice to the world.
Thank you.
I'm much obliged. Do you have any further questions, my lord?
Any further questions?
I'm very sorry. May I just make two very short points before? I think literally in two minutes.
Yes, very well.
One's a very mundane point about the deed, and that is clause 12 of the deed. There is a severance clause there in case any particular provision of the deed is incapable of being enforced. And therefore, and one very final point is we do point your lordships in the direction of an authority dealing with the Brown and Dunn point, because as a matter of candour, the rule has gone through a bit of a change in recent years, and this is a Court of Appeal decision in Ras Al Khamar against Azima, Azima, 2021, 1 CLC 715.
Sorry, 2021,
Yes, sorry?
reference again, 2021,
2021, 1 CLC
yes.
715. The neutral reference is 2021 EWCA Civ 349, and they deal with the various twists and turns in the Brown and Dunn rule at paragraph 80 onwards.
Paragraph
80.
zeros.
Yes, your lordships do have a copy of it. It was sent up at some point with the written submissions. Thank you.
Thank you. Mr. Sonath, is there anything you want to say about that authority? Is there anything you want to say about that authority? Thank you very much. We're grateful to council and those sitting behind them for their assistance. The board will take time to consider its report.
Much obliged, madam.